What if the government passed a law requiring itself to release secret files and then simply refused? And what if a journalist decided that wasn't going to fly and actually took the Department of Justice to federal court to force compliance? That's exactly what's happening right now. And the files at the center of this story involve one of the most controversial and disturbing cases in modern American history, the Jeffrey Epstein saga. This isn't a conspiracy theory. This isn't speculation. This is a sitting lawsuit filed in federal court by a credentialed journalist against the acting Attorney General of the United States. And the legal arguments at the heart of this case could matter far beyond one journalist, one set of files, or even one administration. Let's break down everything you need to know. To understand why this lawsuit exists, you have to understand the Epstein Files Transparency Act. Congress passed this legislation with a specific purpose: to force the release of documents, evidence, and records connected to the Jeffrey Epstein case. The idea was straightforward. The public deserved to know what the government had collected. Victims deserved answers. And if names of powerful individuals appeared in those files, the American people had a right to see them. On paper, this sounds like accountability working exactly as it should. A law gets passed, records get released, journalists report, the public learns the truth. But here's where it gets complicated. The Department of Justice, under the current administration and overseen by the acting Attorney General, has not fully complied with that act. Documents have not been fully released. Access has been blocked or limited. And the justification, or really the lack of one, has frustrated not just advocates and victims, but journalists whose literal job is to report on what the government knows. Enter the journalist at the center of this lawsuit. She is a trained attorney, a legal analyst, and an independent journalist with a significant platform. She covers legal news and national stories, and she has been reporting on the Epstein case, the Maxwell prosecution, and the broader network of individuals connected to what is often referred to as the Epstein elite. These are the wealthy, powerful, and politically connected individuals who allegedly interacted with Epstein and in some cases may have participated in or enabled the abuse of young women and girls. When the Epstein Files Transparency Act passed, she saw it as a turning point. For the first time, there was a legal mechanism, not just a public records request, not just a FOIA filing, but an actual statutory obligation on the government to release this material. As a journalist covering this exact subject, she had a direct professional stake in that release happening. It didn't happen. So on April 27, 2026, she filed a federal lawsuit in the District of Columbia. The defendant is the acting Attorney General. The case number is on record. The complaint is publicly available for anyone who wants to read it. This is not behind closed doors. She went on the record, filed in open court, and is now asking a federal judge to do what the DOJ apparently will not do on its own: comply with the law. Let's walk through what the lawsuit actually argues, because the legal mechanics here are genuinely important. The complaint contains multiple counts, but the core of the case rests on a simple and powerful premise. A law was passed. That law created a legal obligation. The obligation has not been met. Therefore, the court should step in and compel compliance. This is known as a mandamus-style claim in some contexts, essentially asking the court to order a government official to do their job. It's not about damages. It's not about punishing anyone financially. It's about forcing action. It's about saying, "Judge, this law exists, this official is bound by it, and they are not following it. Please make them." The journalist standing to bring this case is grounded in her role as a member of the press. She argues that without access to the full Epstein files, as the Transparency Act entitles journalists and the public to receive, she cannot fulfill her function as a reporter. She cannot verify facts. She cannot cross-reference evidence. She cannot accurately report on who knew what, when, and what role various individuals may have played in one of the most significant criminal cases of the past 2 decades. This is not a trivial argument. Press standing in federal cases has been recognized in various contexts, particularly when journalists are being denied access to information that is legally mandated to be public. If a law says, release this information, and a journalist says, I need this information to do my legally protected work, and the government says no, that's a cognizable legal dispute. A real one a federal judge can and should hear. She also did something tactically interesting in her complaint. She requested the appointment of a special master. Now, a special master is an independent officer appointed by the court to assist in complex or sensitive matters. You might have heard this term come up in other high-profile cases. The idea here is significant. If a special master were appointed, that independent officer could review the Epstein files outside the control of the DOJ, assess what has and hasn't been released, determine what is being withheld and why, and report back to the court. This would effectively take the government's word out of the equation. Instead of the DOJ self-certifying its own compliance, an independent third party reviews the situation. That's a bold ask, and it signals that this journalist and her legal team are not interested in a slow, bureaucratic back and forth where the government drags its feet and claims it's working on things. They want accountability, and they want it to be independently verified. Now let's talk about the broader picture here, because this lawsuit sits at the intersection of several massive legal and civic issues. First, there's the question of executive compliance with congressional mandates. When Congress passes a law directing an executive agency to do something, in this case, release documents, what happens when that agency doesn't comply? The normal assumption is that the executive branch follows the law, but we live in a moment where that assumption is being tested in courtrooms across the country. This case is one more data point in that broader fight. Second, there's the question of press freedom and access. The First Amendment protects the press not just from censorship of what it publishes, but, in various legal interpretations, from government obstruction of its ability to gather information. When a journalist is legally entitled to files and the government refuses to provide them, that implicates core questions about how a free press functions in a democratic society. You cannot have an informed public if the press cannot access the information it is legally owed. Third, there's the Epstein case itself. Let's not lose sight of what these files actually are. This is not an abstract administrative dispute. These are records related to the sexual trafficking and abuse of minors. These are records that may contain names of individuals who have never faced any legal consequence. These are records that victims have been asking to see for years. Every month that passes without release is another month of unaccountability for the powerful people whose names might appear in those documents. The journalist bringing this lawsuit understands all of that. She said so publicly. She made clear that this is about doing her job, but her job in this case is documenting one of the most important and disturbing stories of our time. The stakes aren't just professional, they're historical. So what can you, as a viewer and a citizen, take away from all of this? The first lesson is about the gap between a law's passage and its enforcement. Laws do not enforce themselves. The Epstein Files Transparency Act existing on paper means nothing if no mechanism forces compliance. Courts are often that mechanism, but only when someone is willing to step up, file a case, and fight for it. Most people don't. This journalist did. The second lesson is about standing and who gets to sue. You don't always need to be a direct victim to have legal standing in federal court. If you are a party with a concrete stake in a legal outcome, a journalist who cannot do her job without legally mandated materials, for example, you may have the right to seek judicial relief. Knowing your rights and knowing when you have standing to enforce them is one of the most practically important things any person or professional can understand about the legal system. The third lesson is about transparency as a legal obligation, not just a political virtue. We often talk about transparency in government as a norm, a value, something leaders should embrace. But in this case, transparency isn't just a nice idea. It is written into law. And when the government violates a transparency law, it isn't just bad optics. It is potentially illegal noncompliance, and it can be litigated. Finally, the fourth lesson is about the importance of the press using legal tools to hold power accountable. Journalists are not just observers. When they have legal rights, and in this case, arguably a statutory right to these documents, they can and should use the courts to defend those rights. The freedom of the press is not self-executing. It is enforced, case by case, filing, by people willing to fight for it. This case is ongoing. We do not yet know how the court will rule. We do not know whether a special master will be appointed, whether the DOJ will comply before a ruling is issued, or whether this will be tied up in procedural battles for months or years. What we do know is that a journalist looked at a government that was ignoring its own legal obligations, and instead of accepting that, she sued. If you ever find yourself in a situation where a government agency or a powerful institution is failing to meet a legal obligation that directly affects you, whether as a journalist, a business owner, or a private citizen, the path this journalist took is worth studying. Document everything. Identify the specific legal duty that has been breached. Understand your standing to bring a claim. And find an attorney who knows how to fight in federal court, if that's where your case belongs. You don't have to accept non-compliance just because the other side is powerful. The courts exist precisely for moments like this one. If this situation sounds familiar, if you've been denied access to government records you're legally entitled to, if an agency has ignored a legal mandate that affects your work or your rights, speak with a qualified attorney who handles administrative law or First Amendment cases. You may have more options than you think. And if you want to stay informed on cases like this one, where the legal system is being used to fight for accountability and transparency, subscribe to this channel. We cover the legal stories that matter, the ones that shape how power works and how ordinary people can push back against it.